10, our talkback lawyer David Whiting, Melbourne solicitor, is here to help you with free legal advice. You should call now 1300 222 774, 1300 222 774, and David will help you as best he can. And David, good morning to you.
Good morning, John.
A couple of big legal stories swirling around at the moment. First of all, if you were acting for George Pell...
Yes.
Would you apply to the court for a permanent stay on the prosecution on the grounds that there is a diminished prospect, if not none, of a completely open-minded jury being impanelled and hearing the possible trial?
Yeah, I'd lose credit if I did, John. And I'd lose credit because last week his announcement was that he was looking forward to his day in court.
Yeah, committal.
No, still wouldn't. I would... lawyers are to a very large extent amoral in the sense that you have to tell me, John, who I'm acting for.
Yes. Because
my aim is to present the best possible case for my client.
Whoever they are, yes.
Whoever they happen to be.
Correct.
There's some High Court authority in relation to whether you can or can't get a fair trial in Victoria.
Dupas was the last person to try it, to attempt to say, you can't
because
find
of
a
my
jury with an open
reputation,
mind,
you won't be able to.
Correct.
Yes, yep. In New South Wales, of course, they have a process whereby it can be tried before a judge.
A judge alone, without
Yep.
a jury. We don't have that.
No, and that was always at the option of the defendant, not the prosecution.
Yep.
Anyway, so we don't have that. You'd certainly at least want the committals, the opportunity to put forward your view in the way that he did.
Certainly, it's going to be interesting to see. And other big news, Slater and Gordon announced last week they were recapitalising as of last Friday. So the new the venture capital fund that have picked up the equity in the listed entity that is Slater and Gordon has all but wiped out value for individual shareholders, all 17,000 of them. The class action is negotiations are close to resolving the class action.
John, you have to be, because you look at it from the point of view of the people who are now the owners of Slater and Gordon. There would be absolutely no point in doing that unless you were reasonably confident you could resolve the other side of the deal. Otherwise,
and for a certain amount.
Yes, and you would say otherwise you're buying into something which got some unascertainable liabilities.
Unless you, in fact, are confident that that
you'll get there.
The directors' insurers and the like will pick up the bill under the directors' insurance policies.
So you'd need to be reasonably confident of the outcome, at least within a range, before you could do it.
Yes, that'll be part of your due diligence. But my mail, I don't know what you've heard, my mail is that there's quite a few of the people there saying, well, the culture of the place is going to absolutely, massively change under the new owners, and that's not really the sort of law firm I wanted to work for, so I'll look at my options and there might well be people leaving.
John, I think that any time there's a change in business ownership that you worry about the issue in relation to culture. I mean, you just listened to the news articles they had this morning about a proposed merger of childcare facilities. The suggestion is that if the merger occurs, there'll be a significant change in culture, and as a result, people's expectations won't be met. So, whether it be true or not, from this point of view, it's both the internal and the external perception. But in a sense, it's going to be, if you think of Slater and Gordon as being a law firm that was established by lawyers and continued to be managed by lawyers.
Like 80 years ago, yes.
Yeah, and even more recently. And yes, you do take account of the shareholder interest, but it's still a law firm run by lawyers for lawyers. Is it now going to be, a public company that runs as a absolute straight up and down business?
Well, it was a labour law firm. It came out of the trade union movement. It had an ethos. It had a set of values.
Yes.
And the concern is for people who are attracted by those values of, particularly going into bat for the underdog, asbestos cases, breast implant cases, taking on Octedi and the big mining companies, all of that stuff, that is what is going to disappear. And they're saying, well, that's not what I want to be part of. So I'm watching it with great interest.
Me too. I actually have a difficulty in reconciling what I'll call a publicly listed law firm and the responsibility that you have to the client. Now, there's always a conflict. even if you're a sole practitioner, there's the conflict between the interest that you have to yourself to make sure that your business runs and runs profitably, and the responsibilities that you have to your client. I just think that in a business like this, it just becomes more and more marked.
Short-term versus long-term is one of those dilemmas as well. Any other news in the legal system?
There's a thing that I haven't talked about that came out in the budget. Now, some years ago, the government, probably 2 years ago, the government, or even 12 months ago, the government decided that if you were selling a property worth more than $2 million, you had to report the transaction to the federal government and you needed to get a tax clearance.
For real estate?
For real estate, or an interest in real estate worth more than $2 million. And what you would do is the government treated you as if you were a foreign resident, even if you'd lived here all your life, and you had to get an exemption certificate. So you gave them the required details and they would issue an exemption certificate. And failing that, the purchaser had to pay 10% of the money otherwise due to you as the seller to the government against your tax liability.
Right.
And the aim was that the expressed position was that it was to prevent people who were getting a capital gain pocketing the gain and leaving for overseas. So it was focused on
leaving an empty
residents.
shell to pay the tax.
Right.
Yep.
And at $2 million, that didn't affect a huge portion of the market. Mm-hmm. As of last Saturday, there were 2 changes made to that regime. The threshold came from $2 million to $750,000, and the median price for houses in Melbourne is about $782,000, about that figure.
So many more
people. So at
people.
least half the houses in Victoria will now be caught, and the retention rate's gone to 12.5%.
Right.
So what it does is it poses an extra obligation on the sellers of real estate, imposes a reporting requirement that actually assists the federal government to know basically at a micro level how much properties are selling for, where they are.
And more data matching.
More and more data matching.
So the data matching will also then be, well, hang on, here's a property. If it wasn't your principal place of residence, you've not been declaring it for land tax, you've not been declaring the income for income tax. Hang on, we're going to just embark on a whole lot of other set of inquiries here because of this transaction.
And there's federal legislation that's I don't know whether it's receive the royal assent, that will allow for data matching between state and federal instrumentalities.
Mm-hmm. Yep.
So the tax office will now be able to share this data with the with the land tax office. So one can expect that the government revenues will go up more than they otherwise might have.
Interesting.
So it's but can I say it's the most efficient part of the tax office I've ever dealt with.
Alrighty, shall we get to callers?
Certainly.
No homework or anything like that?
No homework.
Peter in Geelong, morning to you, Peter.
Morning. Whilst I'm still struggling to process the assertion that lawyers are amoral, I'll nevertheless proceed with my inquiry.
Okay.
I'm sitting at my poker machine quietly playing 2 cents at a time. I notice the adjacent machine is vacant but still has $50 worth of credits on it. I do the good citizen thing, put a board up to show that it's reserved, leave it, an hour later the person hasn't returned.
Yes.
I go to the venue and I alert the staff to the fact that there's a poker machine there which has got $50 worth of credits.
Yes.
Are they mine? And the venue goes and checks, has a look, asks me how long the particular unit has been abandoned. I explain. They then take the $50 out of the machine and take it up to the counter. And they'll keep it there for the person to claim.
Yes.
They never claim the money.
Yep.
When I inquire, I said, can I have the money?
But it was never yours, Peter.
What?
It was never yours.
I understand that, but I'm certain that the venue owner doesn't need the $50 either.
Well, we're not talking about whether they need it or don't need it. It's a question of whether they're entitled to it or not. Look at it this way. The way I describe it is that there's a debt owed by the poker machine operator to the customer. And if the customer never collects it, the operator never needs to pay it out.
Isn't it like finding a $50 note on the floor? What's the difference?
Because it's a debt. It's not a $50 note. It's not currency. There's an unused credit owed by the machine operator.
Yes, but what's the difference? Conceptually, there's no difference between finding a $50 credit on a machine and finding a $50 note on the floor, to my mind.
Well, you know who the creditor is in the poker machine. You don't know who the creditor is in the currency.
May I just intervene and say at this point, it does encourage me that should this situation ever arise again, my honesty will become under severe pressure.
Okay.
Peter, easier to seek forgiveness than permission.
Yeah, it certainly is.
Yeah.
Thank you, Peter.
All righty, let's move on. Nell in South Yarra. Hiya, Nell.
Fine, thank you. Do you change the date on a will after 10 years
No, it's the will's still valid. Where is the will at the moment?
with solicitor?
Why would you not drop the solicitor a line that says, I've reviewed my will, it's still current, could you put this letter with the will? Otherwise you have to not just redate it, you need to re-execute it.
Yes, very
And
well.
so that's all I would do. I mean, I had a friend who died a couple of weeks ago, and she last made her will 31 years ago.
Yes.
So, and it still works.
Are you still happy with the content of the will is the question, Nell?
Yes, thank you.
In which case, David, you don't need to do anything.
Thank you.
No. All right. Thank you, Nell.
Bye.
Peter in Parkdale. Morning to you, Peter.
Good morning, gentlemen. I was walking along the Pearn Highway in Parkdale, and I came across a contractor to the power company cutting down a tree on private property. The tree's about 1 metre in diameter at the base and was about 1 or 2 metres in from the fence. There are power lines there. There's a 240 and a 6.6 kV line. Anyway, I asked one of the workmen, what does the owner think about you cutting down his tree? And he said, we've done it with consultation. Anyway, a day later, I'm walking along again and I see the owner cleaning up all the mess that they'd left from cutting the tree down.
I didn't want to take it all away, Peter.
No. I said to him, what do you think about him cutting down your tree? He said, I knew nothing about it. I came home from work and it was cut down.
There is legislation that allows power companies and their contractors to cut trees with where they think it's necessary for the safety of the system.
Yeah, but they didn't trim the tree. They cut the whole tree down.
Well, you might form the view that in the particular tree, you couldn't trim it to the point necessary to make the tree safe and the power safe.
Are they meant to get to at least notify you that they're coming onto your property?
I'll take that as a homework question, Peter. I don't believe that in emergency they are, but on a typical basis, you would certainly hope they would.
It's not. I don't think it was an emergency. That just
No, I understand. I explained that, but look, it may well be that you have appeal rights, but they can go ahead and do it anyway. But I would have assumed they would have assessed the tree well before they turned up with their chainsaws.
Yeah, and I asked the owner. He said the only consultation that went on was between the power company and the council. No consultation with him.
Yeah, and it was inside his fence.
Yeah, inside his fence.
Yeah, John, it was a tree that was 1 metre across at its base.
Yeah.
So it's a fairly
It's a big
large tree.
Yeah, so even more why you'd be annoyed that it suddenly vanished.
And it would have had a significant canopy.
Yeah.
But impacted upon a 6.6 kV power line.
All the more reason why you'd be distressed at its disappearance, in my view, if it was...
Anyway, I would have thought they could have trimmed it,
Or given him the chance to trim it and say, does that meet your requirements and make the power lines safe? I mean, you'd think there'd be that conversation, wouldn't you, Peter?
You
Well,
would
I
hope so.
thought
Yeah.
Yeah, I totally agree.
I'll let you know next week, Peter. We may have a compensation claim for a tree. Let's see.
Right, thanks
Okay.
very much.
Does it create a view that he didn't have before, Peter?
No, you can see more of the highway, but...
Okay, but it's not like a water view or anything like that.
No, it's you can't see the bay.
Because I'm just thinking about, there are those areas where you're near the water in Parkdale, and you're not that far. There are areas along the water where people poison trees in order to enhance their view and improve their property values.
Oh, lots of those.
And then the council put up signs saying illegal tree removal will be countered by the erection of this ugly sign.
Yeah, okay. Very good.
Yeah.
Okay, I'll look forward
Listen
to
next week, Peter. It's one way to guarantee a listener. Thank you.
Thank you.
All righty, good on you. Sunny in Hawthorne, good morning to you.
Good morning, how are you?
Good,
Hello,
welcome
Sunny.
aboard.
I lent some money to my work colleague, about $5,000, about more than 2.5 years ago. And in the process of getting back, I only got $600 in $100 installments. And after that, that person just disappeared from Victoria State. So what do I do in this situation?
Well, VCAT's not available to you. You could issue a claim in the Magistrates Court
Yeah.
to recover the debt of $5,000.
Okay, so...
It's a loan
Sunny,
agreement.
You don't know where he has gone, is what you've said.
I kind of know where that person works.
And do you think that so? Okay, you can serve the summons on them where they work.
Yep.
But it's got to be served on them personally unless they own the business. Do they own the business?
No, they don't own the business.
Right, then it's issuing a summons for service upon them. You can put address unknown on the summons, but at the end of the day, when it comes time to enforce that debt, you're going to have an address to which you can send the sheriff.
Okay, so if I don't have any address, in this situation I can't do anything.
You've got to find them. In order to recover the money, you've got to be able to point an enforcement officer, I don't know whether it's here or interstate, to where they are so you can attach their assets. If you know where they work, you can issue a summons to the employer to get the employer to hand over part of the person's wages. So there's what's called an attachment or a garnishee procedure.
None of which is easy to do, but it can theoretically all be done.
And then somebody leaves their job and you start again.
But the problem that Sunny's got is that it's going to cost some thousands of dollars to chase the 4.5 that's still owing.
Could well, yes.
You understand that too, Sunny?
Yes, so that can be done through the magistrate court, is
yes,
that right?
It can.
Okay.
Takes a while, though.
Thanks so much.
Yep.
Yeah.
And good luck. John in Bendigo, you're through to David. Good morning to you.
Good morning. This is another will question.
Yes.
I represent a historical society in regional Victoria. We had a member who was very keen on collecting, and he died about 5 years ago.
Sorry, fond of collecting what?
Memorabilia.
The kind of thing that the Historical Society also collects. John.
That's right, yes.
Right, okay.
And a number of times said, I will leave this collection to you.
Yes.
After 5 years, we've been to the PROV and had a look at his will, and item 2 says the collection and the cabinet are to go to the society.
Yes.
The society has heard nothing from anybody.
What does the executor say?
Well, we don't know. We haven't talked to the executor. We don't know if the executor is still available. Where should we start looking? Should we go to the executor?
Well, if you've gone to Public Records Office, you will have seen the executor.
Yes.
You've seen the executor's name. Do you know the executor?
No.
Then you might try and contact the executor. When did this person die?
2011.
All right, you can do, if you look at the Supreme Court website, there's a process there for searching advertisements.
Right.
And they have a copy of every advertisement every copy of a notice of intention to apply for probate or letters of administration lodged since about April 2009.
Right.
So you can actually, if you put in the person's last name and their approximate date of death, even the year of their death, they'll be able to tell you whether there was an ad and who the ad was lodged by. That will give you the name of the lawyer, and it will give you the name of the executor and their address.
Right.
So start there.
And what do you then say?
I want the collection, please.
Under the will,
I'm entitled to.
I'm the representative of the Historical Society. Under the will, we're entitled to the cabinet and its collection.
May I have it, please?
Where is it and when can we get it? Now,
can I say, John, not so much for you but for other people who might be listening, it's quite possible that someone who might receive a bequest like that, the asset isn't held anymore. I have people who go from a residence into an aged care facility and move from 6 rooms down to 1.
Yep.
And a lot of things just disappear at that point.
Or they're disposed of.
Or given away.
Despite being mentioned in the will.
Yes. Yeah. So they might not have existed at the time the will was actually signed, or whether the date the probate was granted.
When the will had to be carried out.
Yes.
So, John, if I say in my will, if I say I leave my Rolex watch to David, but when I die I don't have a Rolex watch anymore, he doesn't get the cheaper watch that has replaced the Rolex. He doesn't get anything because I don't have a Rolex watch to leave to him.
Right. We had considered that possibility, but I think we need to act on it.
Yes, you need to check because you've got an obligation to your members too.
Yes. Thank you very much.
Thank you, John.
Remarkably common, actually, those sorts of problems, aren't they, David?
Oh, hugely. I once had a lady who gave away 23 teddy bears, one at a time.
In a will?
In a will, yeah.
Fantastic.
Yeah.
I acted for a deceased estate where someone owned a pub, and the pub was under a particular name, a business name.
Yes.
At the time of making the will, she said, I leave pub A in the name of ABC Proprietary Limited
To X.
to my partner, and he gets the lot. By the time she died, some years later, they'd had a dispute with the tax office. They'd had a dispute with some people about renovations. She'd liquidated that company, and the pub was no longer in ABC Proprietary Limited. It was in XYZ Proprietary Limited. Therefore, the gift
Failed.
didn't go.
Well,
So the business partner said, well, it's clearly her intention to give me the pub. And of course, on behalf of the residual beneficiaries, those who were going to get the pub instead, we had quite a brawl.
I bet you did.
Yeah.
I had a client who left a large amount of money to a university college in Oxford. The only catch was that none of the assets were in his name.
Whoops.
So we had a fantastic executor.
Yep.
Who we had the means of getting it there lawfully. So they were all in a trust. We distributed from the trust to the will estate and thence to the required beneficiary. But it was a few hoops to jump through.
Can well imagine.
That could logically have been ignored.
Yep. Several people texting me saying that our first question about $50 left unclaimed in a poker machine goes to the Unclaimed Monies Fund.
Ah.
And there is a procedure under the poker regulations.
That it goes to the Unclaimed Monies Fund.
Yeah, so that would be worth checking out.
Yeah, and there's also some legislation that came into effect on Saturday in relation to the Unclaimed Monies Fund. It's now an offence to provide false information in support of a claim.
You mean it wasn't before?
No.
Oh, my goodness.
Yeah. You might know about the money, but it's now an offence to lodge false information.
To attempt to try and get money out of it.
Yep.
Good. Lawrence in Sunshine. Morning, Lawrence.
Good morning, gentlemen. How are we?
Very good. Go ahead.
Very, very briefly. Fortunate enough to be able to go over to New Zealand with the mates fishing for a week or two each year. And flying over, we need to take all our rods over in rod holders, etc.
Yep.
They're all put through, fragile, labelled, etc., etc.
Yep.
On the way home, upon getting it home, found that one of the rods was broken.
Yep.
Contacted the airline, and they sent me a nice letter saying that we take no responsibility for items damaged in
value of that one rod, Lawrence?
$300.
$300.
Lawrence, it's all in their conditions of carriage.
Yep.
You're expected to insure them separately. If I was an airline and the rules change differently, I would probably require an examination of every item in every piece of luggage before I would take on the risk.
Yep.
Now, that would add to the amount of time it would take you to go to the airport and would also add substantially to the cost of your airfare. So the answer would be insure it separately because it would be grossly inefficient for that to be a requirement in any changed travel arrangement.
Did you have any travel insurance at all, Lawrence?
Yes, I did. I had.
What's your excess on the claims there?
100.
Right.
And the insurance company was good enough to follow through. I provided them with all the details that they required.
Yeah.
So I was just a little bit surprised by the attitude, I suppose, of emails from the airline. It was very, very dismissive from the get-go.
Yeah.
Okay.
Yeah.
That's how it works.
Yep. Okay. Well,
No, they're shocking. They're absolutely shocking. We once got one of those wheelie cases came off the trolley, off the carousel, and all the wheels were smashed. They do it. You're absolutely just wasting your time trying to get them to compensate you for it.
Yeah. All right. Well, I'll do what my daughters suggested and perhaps tweak them a few social media clips.
Did you catch any fish?
Oh, certainly did.
What were you after?
Trout.
Yeah.
Catch and return?
Yes.
Okay.
Yep, so it was all good.
Excellent.
Next time we'll go back even more prepared.
And I reckon that's the memory you want rather than the broken fishing rod.
Absolutely.
Good on you,
problem.
and thank you. Vicky in East Bentley. Morning, Vicky.
Hi, how you going?
Good. How can we help you, Vicky?
I bought a car last week, and the dealer rang me up this week to tell me there's extra stamp duty on it because on the 1st of July stamp duty went up. And my question is, does stamp duty apply on the date of the contract or on the date of the pickup?
When did you pay?
On the 25th of... Oh, we haven't paid yet. We're paying the balance when we pick up the car.
I would say it's the day you pay the price. So if you'd completed the transaction last week, there would have been no duty.
No extra
duty. You bought it this week. It's gone up. And for those people who want to know what the stamp duty is on motor vehicles, I can tell you because I had a look.
How much has it gone up, Vicky? Do you know?
It's $190 odd dollars.
On the total transaction for the whole purchase of the car?
Yes.
It's an extra 190, so it's a fractional increase in stamp duty.
It's not much, but, it's...
Yeah, 190 is $190. Yeah,
it's
absolutely.
gone to... It used to be $8 per $200 in value.
Right.
It's now $8.40.
Right.
All right. So that's on new cars. That was what's been on used cars for a while.
Yep.
$8.40. So it used to be $40 a thousand. So it's gone up to just $42 a thousand.
Oh, okay.
All right.
All right. No, thanks for that.
Sounds like an expensive car.
When do you get your new car, Vicky?
Well, I'm supposed to pick it up today, so
And?
I'm excited. Yeah.
And?
And, sorry?
And it's going to be ready?
Yeah, today.
Yeah.
And are they going to give you a little show bag with, some car care products and a
Oh,
sponge?
I hope so. That'd be nice.
Oh, well, good luck with it.
And just enough petrol to get you to the service station. Thank you, Vicky.
Oh, dear, make sure you've got the insurance sorted out. Can we grab a few more callers after the news headlines? Sure. Our talkback lawyer, David Whiting, helping you with free legal advice with a few more calls coming up. 1300 222 774 is always the number. More calls after the latest from the newsroom with Tim Callanan, and thank you very much, Tim. Stephen Bentley, good morning to you. Stephen, thank you for holding on.
Okay. I'm just asking, I've got a LCD that was delivered to me by my kids from Sydney to Melbourne.
Yes.
And it arrived here with the whole screen has been damaged big time. I'm trying to get them to actually replace the TV or get some refund of them. They deny everything else because I wasn't insured.
The claim would be made, if there was a claim, it would be against it would be whoever arranged the cartage. Was that you or your children?
My children.
So if your children from Sydney sent you a television down here, then they're the people who contracted with the courier, and it's up to them to make a claim. But again, we talked a little while ago about terms and conditions of cartage. Yeah. You will probably find that there is a limitation on the cartage claim, and which you can address by taking out insurance. So they're probably right.
Because the only problem is they delivered to someone else, and the product was actually there for a day or two. Someone already signed for it, and I couldn't find. The only reason why I actually found out when they actually emailed me that the property the item's been delivered already, and I don't have it. And also when I called back to them, where's my item? It's not even here.
So, sorry, Steve, it was delivered to the wrong address? Is that what you're saying?
Yes, and it was already signed for it by someone else, not me.
So the next problem that Steve's got, David, is saying that the damage was caused while it was in the hands of the courier rather than the other people it was delivered to.
Yes. So you've just got a bucket load of problems.
It is. I was actually trying to get... Yeah, they actually dragged me. They said they to fill up the insurance policy. But they wait for 2 weeks to actually send me to tell me that I'm just out of the hand.
Did the people you delivered it to the people that they delivered to first, did they open it?
Who knows? It's been there for 2 weeks, a TV. If you receive a free TV for you, would you open it?
Well, probably. In fact, inevitably, yes. Steve, I would. If you could contact those people, ask those people. Because if it was damaged as a result of the misshipment, then I think you've got a stronger claim than if it was just, if had it been delivered to you directly and came damaged. But your prospects of success are not great. They exclude all of the liability that they can, and they then offer you insurance.
Good luck with that, Steve. Chris in Melville. Morning to you. Chris, where's Melville?
Morwell, in fact.
Morwell. Okay, thank you.
I think Melville Road.
Right.
Morwell. Okay, yep.
Small problem. I shifted a heap of office equipment into a self-storage garage recently. I went back 3 or 4 days later, and it had been raining in the previous day or two, and the roof had a leak. It flooded a heap of my equipment and office furniture and so on.
How?
Now, when you read the fine print, of course, you're excluded from any leakage and spillage from neighbouring storage units and so on.
No, Chris,
but
I'd have a go.
Roof to work.
How much is the loss? Dollar value of the loss?
Oh, look, I haven't really added it up, but it's not a huge amount.
Ballparks?
Oh, it'd be less than $1,000.
Right.
Chris, I would suggest that's if it's it's not a question of leakage from the adjoining storage area. It's leakage from the roof. You're entitled to assume that they're going to give you a watertight storage facility.
It's what you're paying for, isn't it?
I'd have a go.
I could have left it
And
out
my
in
argument,
backyard.
my argument would be that that's an unfair condition in the contract, or a breach of an implied warranty that the roof would be watertight when you in fact stored the goods.
Yep.
Right?
Right.
Give it a go if you want to.
I will. Thank you.
Thank you.
Bye.
All righty. And some of our listeners by text message are much more devious than you or me, clearly, David. The television that was delivered from Sydney and doesn't work after 2 weeks with the neighbours.
Yes.
Is it the same TV that the kids sent down?
Text message. Did turn my mind to that.
Oh, I didn't. See, I didn't even think of that.
No, I just wondered whether you might argue that wasn't the telly.
Yeah.
And that would make an interesting mess, wouldn't it?
It would. Lindsay in North Fitzroy. Morning to you, Lindsay.
Morning.
Lindsay.
I'm a window cleaner, and I've been cleaning windows for about 14 years. I just often get mucked around by councils doing roadworks and stuff on the street and on the road. I'm just wondering if there's any way I can claim for because people don't want. Sometimes I don't have access, and sometimes people don't want their windows cleaned when there's dust and excessive dust around.
Because it won't stay clean for long enough.
Yeah.
Okay, right.
Lindsay, not a hope in hell.
Okay, all right, no worries.
They're doing what they're entitled to do. I mean, one could argue that they should ask you for a licence to do window cleaning because you're standing on the footpath. I'm being very difficult, Lindsay, but I'm putting the contrary point of view. No, I don't see you've got a claim. If they're doing roadworks that are part of their function under the Local Government Act, I don't see you've got any basis for interference to your business.
Okay,
Sorry.
all right.
Thank you.
Lindsay, before you go, I once saw a very interesting film about window cleaners. Have you ever seen that one?
Called? No, what was that?
It was something to do with Confessions of a Window Cleaner.
Oh, no, it sounds horrible.
You don't do the high-rise stuff, do you?
No. I was plenty of work down here in terra firma.
Okay, well, that sounds like a good idea.
Yeah.
And you shouldn't have admitted to seeing the movie anyway, Lindsay. Yeah, that's my approach.
And needless to say, I've never seen it either.
Of course, John.
No, I've never seen anything like that. No, not at
And you
all.
tell everybody you're a man of the world. Yeah.
And just finally, can we do one more?
Sure.
Murad in the city's been waiting for a very long time. Apologies, Murad. You'll be our last caller with David today.
Yes, Murad.
Yes, I just like explains to your
Producer.
telephonist. Yeah,
Start from scratch. David doesn't know what you've said to them. What's the problem and how can he help you?
All right, I got married like 6 years ago, and with my ex now we've been breaking up for like about 5 times. The last time is the 5th time, which has happened about a couple of years ago. We've been separated as we lived together in some stage, which is the last one. And in that period, I bought a house. I bought a mortgage. I took a mortgage for a house.
Yes.
But we were separated at that time. Then after we took off the separation...
So how long ago were you separated, Musad?
We've been...
Sorry, when did you buy the house?
2 years ago.
And before that, how long were you separated?
We separated on and off for the period of probably 1.5 months.
I'm interested in the total period. So if we go back from now, how long have you been separated?
About 1.5 years now.
So you've been separated for 1.5 years. Well, you're certainly eligible for divorce. Look, the only claim that she might have would be against the money that you put into the property when you bought it. Right? So I would have seen it as a very small claim.
The deposit, you mean?
Well, yeah, and you borrowed the rest?
Yeah.
Then it would be the best claim she would have would be part of the deposit. All right. Thank you, Masood.
So good luck with that, and I hope you're able to sort out those issues as best as possible. David, thank you. It's been an extended session. I'm grateful to you, and I'm sorry to those people who are still holding. There are people who are still waiting. And David will be back at the same time next week if you did get through today. 1300 222 774, though, next for the open line.